Morning, colleagues from the DOJ. We're informed Ms. Tabisile Mahlang is going to be sharing today. Can you test your system, ma'am? Morning, Ms. Pillay. I will put you as backup, just in case. Mr. Raman, am I audible?
No, yeah, Bakala.
See, colleagues are not responding. Okay. Ms. Tabisile?
Yes, sir, you are audible.
Morning, Sia.
Yes.
Yes.
For today, your team who's sharing, I'll put you as backup.
Yeah, can I just test my yes.
For
Which
today,
one are
your
you
team
doing?
who's sharing,
Which
I'll put you as
presentation?
backup. Whoever will be projecting
Yeah,
today
can I
must
just
quickly
test
sort it out now
my
before we start.
yes.
For
Which
today,
one are you
your
doing?
team, I'm not sure what the order will be, but I'm trying to give whoever a chance to test their system now, whoever will be
Okay.
presenting today. So I'm sure you will be back up for the bills, and I don't know who's projecting. Will you also be projecting, Ms. Pillay?
Yeah, I will project the National Prosecuting Authority one. I can also do the RICA one for my colleagues because they have problems with their system. So okay, so here's the NPA one.
Can you move
see
it? Yeah, I'm looking at it. Can you move it?
Just 1 second, let me put it on slideshow. Right.
Yeah, it's working. So the other one should work too. So okay. Ms. Tabisile, Ms. Mahlangu, I was informed. Thanks, Ms. Pillay. You can remove it.
Okay.
Recording in progress.
Good morning to everybody.
Morning, Chair.
How are you, Honorable Swart?
Very well, thanks. Yourself?
Thank you very much. I'm okay, thanks. So, can we start? I propose that we start with the judicial matters. Will that be fine? Welcome, Deputy Minister. Can I have the judicial matters flighted? It was circulated. It will be taken as read. Thank you very much. We have gone through the bill clause by clause. The final bill was circulated. Are there any problems with clause 1? Clause 3? Clause 10? Clause 11? Clause 36? No, before that, can you go up a little bit? Yes, sorry, no, go down. Go down. Go down. Go down. Clause 30. Clause 36. I now put the bill as a whole. Is there a seconder for the bill to be adopted? Honorable members, I now put the bill. Is there any seconder for judicial matters bill to be adopted?
Would seem there is no appetite, Chair.
Honorable Neo Druchen, seconds, Chair.
Any objections?
We reserve our position, Chair. Good morning.
Morning, how are you?
Well, thanks. How are you?
Thank you very much.
Good.
Thank you. There is no objection. The DA reserves its position. The bill has been duly adopted. Can we now deal with the report?
Chair, my
Honorable
apology.
Honorable Chele. Honorable Chele. Let's proceed. A report of the Portfolio Committee on Justice and Correctional Services on the Judicial Matters Amendment Bill B7 of 2023.
Or if it has been adopted, it's fine.
Dated 8 September 2023. The report was circulated, therefore it will be taken as read. Are there any corrections on page 1? Page 2. Page 3. Is there a move for the adoption of the report?
Druchen moves for the adoption of the report, Chair.
Honorable Nivot Druchen moves for the adoption of the report. Any seconder?
Yeesh. Struggling.
Are you seconding, Honorable Breitenbach?
Oh, no.
Any seconder? The report has not been seconded. It will stand down. Thank you very much. Can we move to the next item? Honorable Deputy Minister, which are you going to start with, RICA or NPA?
I think let's start with RICA. I see Honorable Maseko Jele has left, so I think she was having connectivity problems. But yeah, I think if the presentation can be flighted, but just let me say some introductory words or comments. This bill is dealing with the Amambungane Center for Investigative Journalism and another versus the Minister of Justice and Correctional Services and others. And it's relating to sections of RICA that were declared as unconstitutional. The bill is late. It has to be passed by early February. The problem was initially the intention from the department was to redo RICA. But then there were, I suppose, what one could call capacity problems in terms of particularly COVID and the official working on the bill becoming sick, other officials passing away because of COVID. And so that was to a large extent the reason for the delay. The department, I'm sure, can give more details. But what we've done because of the time is to focus just on the issues that the Constitutional Court identified as needing to be addressed. So the issues basically were issues relating to the appointment and the independence of the designated judge, which is already there. There were issues raised around the fact that the applications for interception orders are obviously ex parte. They're made by the authority wanting to make them. And the subject can't be notified because if they did, they would stop using that particular communication method, phone line, whatever. So there were concerns about that from the courts. There was also issues of ensuring that the orders were reviewed. There were policy options that we had on the ex parte aspect. The court did look but didn't make a ruling on the fact of whether there should be a public advocate who represents the subjects against whom the orders are being sought. What we've opted for in the bill as a policy option is to provide and kill two birds with one stone, to provide for an additional designated judge who would review the orders and the decisions of the designated judge. Then there was issues relating to ensuring safeguards for practicing lawyers or journalists, because there had been abuse, and that was the reason that the Amambungane brought the case. And then the other issue is the question of post-subject notification, where the subject does need to be notified that they were intercepted after the interception is complete, and the officials will explain how that works. And then lastly, ensuring adequate procedures to ensure that data obtained during interception of communications is managed lawfully and not used or interfered with, and setting out procedures to be followed for examining, copying, sharing, sorting through, using, storing, or destroying the data. So, Chair, the bill is basically to address the issues raised in the Amambungane judgment, in the court order of invalidity. Some of the issues are narrower, some of them have got a wider ambit. There was a reading in done, but we don't have to exactly follow that reading in. That was for on an interim basis. But Chair, having said that, let me hand over to DDG Pillay and her team. I'm not sure who's going to present on the bill. Thank you, Chair.
Thank you very much, Deputy Minister, for the introductory remarks. DDG Pillay.
Good morning, Chairperson. If it's okay, I will not use my camera due to our connectivity issues. This morning, I am joined by Advocate Sibela Mecha and Alison Botha, who will take us through the presentation. I will be sharing the presentation from my side. Thank you, Chairperson. If I may call Tsietsi, and with your permission, Tsietsi and Alison.
Thank you very much.
Thanks, Chair, and thanks to the DM and my DDG for the introduction. I'm going to jump straight into the purpose of the presentation, which is to brief the Portfolio Committee on, I'm going to call it the RICA Amendment Bill, just for ease of reference. The background of the bill lies squarely, as the DM has said, in the Amambungane judgment. So on the 4th of February 2021, the Constitutional Court handed down judgment in Amambungane. And that judgment confirmed the declaration by the High Court of Pretoria, that RICA is unconstitutional to the extent that it fails to provide adequate safeguards to protect the right to privacy, as buttressed by the rights of access to court, freedom of expression and the media, and legal privilege. The Concord declared RICA to be unconstitutional to the extent that it fails to, we're now on the next slide, please, DDG. Thank you. So Concord declared RICA to be unconstitutional to the extent that it fails to provide for safeguards to ensure that a judge designated in terms of Section 1 is sufficiently independent, provide for notifying the subject of surveillance of his or her surveillance as soon as notification can be given without jeopardizing the purpose of surveillance after surveillance has been terminated, that RICA fails to adequately provide safeguards to address the fact that directions are sought and obtained ex parte, fails to adequately prescribe procedures to ensure that data obtained pursuant to the interception of communications is managed lawfully, and isn't used or interfered with unlawfully, including prescribing procedures to be followed for examining, copying, sharing, sorting through, using, storing, or destroying the data, and it fails to provide adequate safeguards where the subject of surveillance is a practicing lawyer or journalist. The Concord suspended the declaration of unconstitutionality of RICA for 36 months to afford Parliament an opportunity to cure the defects which caused the invalidity. The Concord did grant interim relief by the way of reading in 2 provisions in RICA, and those provisions deal with the disclosure that the person in respect of whom a direction, extension of a direction, or entry warrant is sought is a journalist or practicing lawyer. And the other provision, the interim provision, deals with post-surveillance notification. And those two provisions which were read in will operate for the duration of the suspension. So an amendment to RICA is required in order to address the defects which we had covered in the previous slides. And that must be done within the set deadline of 36 months. And that deadline is 4 February 2024. We now move on to a discussion of the bill. And the bill seeks to amend RICA to primarily address the issues decided in the Amabungane case. And those are 5 main issues, being the notification issue, the independence issue and the designated judge, the ex parte issue, the management of information issue, and journalists and practicing lawyers issue. The bill inserts certain definitions. It provides for the designation of an independent designated judge, provides for the designation of an independent review judge, provides for the powers and functions of the review judge, provides for the tenure of designated and review judges. It provides for adequate safeguards where the subject to surveillance is a journalist or practicing lawyer. Provides for post-surveillance notification. It provides for adequate safeguards to address the fact that interception directions are sought and obtained ex parte. Provides for adequate procedures to ensure that data obtained pursuant to the interception of communications is managed lawfully and not used or interfered with unlawfully. Provides for procedures to be followed for processing, examining, copying, sharing, disclosing, sorting through, using, storing, or destroying of any data. Provides for principles for the safeguarding of data when dealing with management of data. And it provides for matters connected therewith. We're now going to go through the bill clause by clause. So clause 1 amends section 1 of RICA by inserting certain definitions, including designated judge, and amends the definition of designated judge, and it includes definitions of prescribed, review judge, and this act. Clause 2 inserts chapter 2A, and that inserts clause 15A to 15D in RICA. Clause 15A provides for the designation of a designated judge. So the minister must designate a designated judge in consultation with the Chief Justice by notice in the Gazette. A designated judge must perform all the functions conferred upon them independently and without fear, favor, or prejudice. Clause 15A further provides that a designated judge is required to, in respect of an application in terms of the sections listed, within 5 days of the decision to issue an order, judgment, direction, entry warrant, deferral order, or any of the other documents mentioned, to refer that information or documentation considered in arriving at the decision, together with a copy of the decision, to the review judge. Also requires the designated judge to, in respect of applications in terms of section 23, which deals with oral entry warrants, and after issuing a directional entry warrant under subsection 3, or for an oral direction or oral entry warrant under subsection 7, and for a decision under section 11, immediately refer a copy of the decision to the review judge. Clause 15A further makes provision for the immediate implementation of the decision by the designated judge, pending the review thereof by the review judge, and that's in terms of section 15C1. Clause 15B provides for the designation of the review judge, and the minister must designate a review judge in consultation with the Chief Justice by notice in the Gazette. Clause 15C provides for the powers and functions of the review judge, and it provides inter alia that the judge must, in respect of an application in terms of sections 16, 17, 18, 19, 20, 21, or 22, within 5 days of the receipt of the information or documentation considered by the designated judge, and a copy of the decision of the designated judge, the review judge will consider and either confirm, vary, or set aside the decision of the designated judge. Clause 15C further requires the review judge to, in respect of an application in terms of section 23, confirm, vary, or set aside any decision of the designated judge immediately or as soon as practicable upon receipt of the decision. Clause 15C further requires that the decisions of the review judge must be delivered to the designated judge, who must then in turn inform the applicant of the decision of the review judge. Clause 15C also provides that any decision by the review judge must be executed immediately upon receipt by the applicant. It also provides that the review judge must keep a record of the exercise of any power and the performance of any function. Finally, Clause 15D provides for the tenure of the designated and review judges, and it provides for a non-renewable period not exceeding 7 years, and for the termination of the tenure. Clause 3 inserts Clause 23A in RECA, and it provides that when the person, in respect of whom a direction, extension of direction, or entry warrant is sought, is a journalist or practicing lawyer, that the designated judge must grant the direction, extension of a direction, or entry warrant only if satisfied that it is necessary to do so, notwithstanding the fact that the subject is a journalist or practicing lawyer, but on the conditions necessary to protect the confidentiality of the journalist's source, or in the case of a practicing lawyer, to protect the legal professional privilege enjoyed by his or her clients. Clause 4 inserts Clause 25A in RECA, and that provides that within 90 days of the date of expiry of a direction or extension issued in terms of the sections mentioned of RECA, the person who was the subject of the direction must be notified in writing of such direction. The applicant that obtained the direction, or if they're not available, any other law enforcement officer within the law enforcement agency concerned, must notify in writing the person who was the subject of the direction, and within 15 days of doing so, certify in writing to the designated judge, judge of a high court, regional court magistrate, or magistrate, that the person has been so notified. Section 25A2 provides for the withholding of the notification on 2 bases. First, jeopardizing the purpose of the surveillance, and second, the potential to impact negatively on national security. The former allows for the designated judge, judge of a high court, regional court magistrate, or magistrate, on application to direct that the notification be withheld for a period which must not exceed 90 days at a time or 2 years in aggregate. And the latter allows for the designated judge on application to direct that the notification be withheld for a period as the designated judge may determine. Clause 5 amends section 35 of RECA by deleting paragraphs F and G in subsection 1, and they deal with information to be kept by the head of an interception center and the manner in which and the period for which that information must be kept. On the next slide, please, DDG. Thank you. Clause 6 amends Section 37 of RICA by providing that the head of an interception centre must keep or cause to be kept proper records of such information as may be prescribed. Clause 7 inserts Clause 37A in RICA, and that provides for procedures to be followed for the processing, examining, copying, sharing, disclosing, sorting through, using, storing, or destroying of any data obtained pursuant to, resulting from the interception of communications in terms of RICA and any other act. And that data must be kept in the prescribed manner and on the prescribed conditions. It also provides for principles that have to be taken into account regarding the management of data. And that includes accountability, processing limitations, the purpose-specific processing of data, conditions for the storage of data, and security safeguards. Clause 8 inserts clause 62D in RICA to provide that the minister may make regulations, and any regulation made which may result in the expenditure of state monies must be made in consultation with the Minister of Finance, or any regulation which has a bearing on any designated or review judge must be made in consultation with the Chief Justice. Clause 9 provides for the laws amended and provides in the schedule for the amendment of Section 3 of the Intelligence Services Oversight Act 1994 by the substitution of in paragraph A for subparagraph 3. The amendment provides for the review judge, in addition to the report by the designated judge, to submit a report regarding his or her functions, and together with any comments or recommendations that the review judge may deem appropriate, provided that such report shall not disclose any information contained in an application or direction referred to in that act. Clause 10 provides for the transitional measures. So it provides that any judge whose designation prior to the commencement of the bill is still in force will remain in force for 5 years from the date of commencement of the bill. Also provides that any of the documents they mentioned that were issued or made prior to the commencement of the bill, which is still in force at the date of the commencement of the bill, must be regarded as having been issued under the bill, and so it will remain in force until the period or extended period for which the order, judgment, direction, entry warrant, deferral order, declaratory order, oral direction, oral entry warrant, subpoena, notice, or other process was issued or made lapses. And all pending matters must further be dealt with in terms of the bill. Clause 11 amends the arrangement of sections by just inserting new clauses provided from the bill. And finally, Clause 12 contains the short title and date of commencement. Thank you, Chair.
Thank you very much, Ms. Bota. Members, any comments or questions? Honorable Swart, followed by
Thank you. Thank you, Chair. I appreciate these. This is a preliminary briefing by the department. Obviously, the question which I would like the department to answer, and it is a perennial question which we raise in the Chief Whip's Forum when it comes to constitutional court deadlines and the delays in bringing bills that are far-reaching to Parliament and placing undue pressure upon Parliament, both the National Assembly and the NCOP, and then for the President to also go through it before he assents or sends the bill back to Parliament. The challenge I've got is that here we were given 36 months as Parliament, and we're only getting this briefing at this late stage. I would need a more acceptable explanation from the department. The DM tried to explain, and he said the department will further elucidate on that. But it was the minister as well that indicated during the court hearings that, and requested his representative requested 3 years because it was going to be a total review of the bill. And now we are dealing not with a total review of the bill, as the then designated judge in 2014, Judge Machoro, requested an extensive review, but we are dealing with a few amendments purely to bring us in line with the Constitutional Court order. And so I would require an apology, at the very least, but a full explanation as to why we are now under such pressure at this very late stage. Secondly, another major issue is, of course, trying to strike the correct balance between what RICA serves as an important government purpose, fighting crime, surveillance, which we all support, but at the same time, the very real abuse that has been taking place by intelligence authorities, by law enforcement authorities, as pointed out by the previous designated judge, and trying to strike that balance. And I think that is an ongoing challenge for us. But one of the big concerns is the clause which now allows for that post-surveillance notification, clause 4 of the bill, which amends section 25, insertion of 25A. One of the main constitutional defects was the lack of notification of surveillance. And clearly, again, I appreciate a balance has to be struck. And we're all in favor of fighting crime. But when will you balance this against possible abuse? Is it warranted for this exemption that has now been set out under terms of national security, which, as the Zondo Commission pointed out, has, or not necessarily the term national security, but we know that there has been abuse by the national security apparatus during state capture. And so we need to be very sensitized, and we need compelling reasons as to why that exemption of 90 days and on aggregate 2 years may be granted. Yes, a judge must grant that, magistrate. But again, this is something that we need to consider very carefully. Thank you, Chair, for allowing me those few comments at this early stage of the bill.
Thank you very much, Honorable Swart. Honorable Breitenberg.
Thank you, Chair. Good morning to everybody. I align myself with the comments of the Honorable Swart. It is so that the date for submission of this bill was extended for 3 years, so that we could overhaul all the problems that there were with RICA and come with a comprehensive, new, acceptable piece of legislation. Now, this is not that. This is just a cut and paste exercise that's sticking elaster plaster on a wound that requires stitches. It's not acceptable. The explanation given by the Deputy Minister, with the greatest of respect, is completely unacceptable. To suggest that there was some hold-up as a result of COVID it cannot be accepted, simply because there was so much less to do during COVID that everybody had more time to do their work. And so sitting and drafting should have been the easiest thing in the world to do during COVID. So to blame COVID for the lack of progress on this matter, it doesn't fly. And this committee, Chair, is under a huge amount of pressure right now to deal with a lot of legislation that's coming in one big tranche that should have come in the normal course, in a more well-planned, more manageable fashion. We're forced now to deal with very important legislation that has far-reaching effects under great pressure and under great time pressure. It's not acceptable. We're supposed to have enough time to interact with all the legislation. We're supposed to have enough time to apply our minds properly. We're not busy with playing games here. This legislation has far-reaching effects on everybody, including the citizens of this country. And we're constitutionally required to do a good job. And under this kind of pressure, it's really hard to do. So I find the rush undignified. I find the pressure on the committee unacceptable. And I find the fact that, that this is yet another, just yesterday we did a cut and paste, yet another cut and paste is what the department is becoming known for. It's not acceptable. It's not their job. It's not what they're supposed to do. They're making it impossible for us to do our job. So I find the whole business extremely dissatisfactory. As far as this piece of legislation goes, Chair, it has far-reaching effects. It's invasive. It has far-reaching effects. It perpetuates the environment of abuse that we've seen in the past. And South Africa has a past of abuse in this arena, not limited to recent times, I'm happy to concede. But nevertheless, we're here to do better. We're here as a democratically elected parliament to do better for South Africans, and we're not. We need legislation that takes into account that we're a constitutional democracy. We need legislation that takes into account that citizens actually have rights. Of course, we have to fight crime. Of course, security services need to be able to conduct surveillance. All of that is true. But to allow so small a handful of people so much power in this regard, I would need a lot more time to consider this piece of legislation. Thank you, Chair.
Thank you, Honorable Breitenbach. Honorable Jala.
Thank you very much, Chair. Good morning, colleagues and DM and the team. Chairperson, my apology for earlier. I'm on load shedding and I'm in and out, so I miss lots of things that are happening this morning in the committee. But Chair, let me just say we are welcoming the presentation of this bill, and also noting that it is really, the time is not going to be enough for it to be well, maybe interrogated, but because of the law, the work that is coming to the committee, and also the deadlines of the court, now we find ourselves in this situation. But I think I would just echo the words of the colleagues that the department has to improve in making sure that they give the committee enough time to deal with this important. This is, yes, an important bill, very important. But for now, we appreciate the presentation and note, Chair. Thank you very much.
Thank you very much. Over to you, Minister.
Sorry, just
Okay, we didn't want the DM to run out.
sorry, Chair. It was just that somebody outside was coming with a machine to do things in the garden, which was making a noise. So my apologies.
Surveillance
Not
or not?
a surveillance machine, no.
Spying on you, Deputy Minister.
Sorry?
They're spying on you.
Well, I'm not so paranoid, Honourable Breitenbach. Look, I think in terms of the responses, the department must respond on the issue of the lateness and why it took so long. I just wanted to respond in particular to Honourable Breitenbach and Honourable Swart. RICA is invasive, but this amendment is not extending any of the invasiveness, it's actually limiting it. When it comes to the post-subject notification, which wasn't there before, it is, as Honourable Swart said, a balancing act. We've opted here for a 2-year maximum period for under 2A. There wasn't great happiness with that from particularly the NPA and the police, who feel that sometimes investigations into complex organized crime can take 5 years. And obviously, once you've notified a person that they were under surveillance, person of interest who may be put under surveillance, then you stop doing that, then you want to do it again. They're obviously not going to, or they're going to be a lot more careful about what communication means they use. So we've put in 2 years. It may be useful for the committee to hear from the NPA on that issue. On the national security issue, the issue there, I mean, again, it's within the powers of the designated judge, and there may be issues affecting the national security of the country, involving foreign governments, where there would need to be surveillance on and off for a longer period of persons of interest. But those are things, Chair, I think in the deliberations on the bill, it is, as Honourable Swart said, an issue of striking a balance. But I just wanted to say that there is another side to it. The court had read in a 2-year maximum period. It hadn't actually specified that must be the maximum. So that could be looked at. So, Chair, I just wanted to respond on those 2 points, but then I think the department can respond on the other issues over the lateness. Thank you.
Thank you, Deputy Minister. Ms. Pillay.
Thank you very much, Chairperson, for the opportunity to respond to the criticisms of the committee with regard to the delays. I think, firstly, let me start by apologizing for the bill being late. But I do want to set out the circumstances so that the committee can take those into account. Firstly, our unit on legislation is now made up of 90% new officials who were appointed in the last 2 years. When one of the officials retires in November, we will have only one official that has been there for more than 8 years. That's the first point I want to raise. Secondly, this is a very highly technical bill. We do have a full bill that has been drafted that is about 135 pages long. It has not been consulted upon. And as we were trying to address the issue of the Constitutional Court deadlines, we also had to consult with other departments, which is why we came up with a shorter bill to be able to address the court deadlines. So this is not a cut and paste. And Chairperson, if it was that simple, we would have done that long ago. These are literally new provisions in the Act that we are proposing to include in the Act. We had to apply our mind to the Constitutional Court deadlines and what would be sufficient to address the court deadlines and to give us a workable RICA Act until the Act is fully reviewed. And as I said, Chairperson, this is a matter dealing with technological issues in an environment that is developing all the time. In fact, I was told by the officials that passed the RICA that the day it was passed, it became outdated. And this is how difficult this matter is. And we are doing our best to work within the resources that we have available to us. And we will try better next time. Hopefully, there will not be a matter as complicated as RICA for us to deal with. But Chairperson, I leave the rest in your hands. Thank you.
Thank you very much, Ms. Pillay. I think there is generally a tendency of thinking that once the department has finished the bill, you have complied. And this is not the first bill that came very late. The cannabis bill came to us when we were left with only 2 weeks to deal with the bill before the deadline. And now the issue is that the department knew all along that people are retiring. Honorable Janji has always raised the point of a risk register. Now, if you are as senior managers, is a risk that you should always be grappling with. That how do you manage a situation where there is going to be a high turnover of people retiring and new people coming in. What is going to be the impact of that in terms of the quality of the work that you need to do? Because I think this has been a continuous challenge, and I do think that chances are that the 7th Parliament would have much more or less the same challenge or even more. What are you doing to ensure that, given all those challenges that you have, but you ensure that you submit bills earlier? Because when you deal with Parliament, you're not dealing only in terms of the compliance for the National Assembly. You also have to take into consideration that there is a National Council of Provinces. Now, even if we comply and we pass this bill in October, the National Council of Provinces would only have November and beginning of December to deal with this bill. They're still grappling now with the hate crimes, hate speech that is in front of them, and many other bills. And we know how the National Council of Provinces is constituted. They are very few, dealing with a lot of bills from the NA. I don't think that the department is really applying itself seriously in dealing with this particular matter. We have been raising the issue of late bills coming to Parliament since the beginning of the term. We have been raising this thing since the beginning of the term. So I do think that with all the bills that we are passing, Deputy Minister, we are really pushing pressure to the National Council of Provinces, unduly so. Unduly so. We do know that you have challenges with resources, but I do think that a big part of it is just a lack of proper planning on the side of the department, because it's the department and the executive that plan legislations and send those legislation to the leader of government business. You come to us and say, these are the priorities for the year. You come to us and say, these are the priorities of the year. Now, the issue is in determining those priorities, don't you take into account that you have limited human capacity on your side? And that limited human capacity needs to be deployed in a strategic manner to ensure that you properly prioritize your work. Because we can't really afford a situation where Parliament every time is not going to be in a position to pass bills, not because it does not have capacity, but because legislations come to us very, very late. And in a way, you are putting gun on our heads, because we'll be saying, no, this is a constitutional court deadline. The deadline has to be met. Not taking into consideration that you are not giving us enough time to apply ourselves and discharge our responsibilities. Really, I do think that colleagues are really, I mean, what they are raising is really a sore point for us. Because you are making us not to be in a position to discharge our constitutional responsibility in a fair manner. You know that you have a challenge of people retiring, that we have known it all the time. So I do think that before we adjourn this year, you have to come before us during the BRRR reports to say what measures are you going to be putting in place to ensure that bills come to us in time? How are you going to ensure that the people who are retiring have really transferred skills to the new ones? Because we can't be raising that thing to the constitutional court that the reason that we are bringing bills late or we are asking for extension is because the department did not know that they have new people are retiring. It won't fly. It won't fly at all. So thank you very much. Can we go to the next bill?
Chair, thanks. The next bill is the NPA Act Amendment Bill, which I'm sure they can flight the presentation, but just by way of introduction. The President established the Investigating Directorate by Proclamation number 20 in 2019 in terms of Section 7 of the National Prosecuting Act. And that was to investigate in particular matters against corruption. Over the last 4 years, the Investigating Directorate has enrolled 34 matters with 203 accused. During the last financial year, it enrolled 18 new matters and authorized 13 new investigations, totaling 97 matters authorized over the previous 4 years. The ID also contributed significantly to the recovery of 2.5 billion rand, which was paid into the Criminal Assets Recovery Account. The problem is that the ID, the Investigating Directorate, is not permanent. It was established by proclamation. It can be disestablished by another proclamation. And obviously, with the lack of permanence, this makes it more difficult to attract investigators to commit themselves to an organization that may not even be there tomorrow in theory. The second problem that the ID have is that their investigative capacity is limited by having to largely rely on seconded investigators. And we've seen, I think, Chair, the members, the problems in the Nulane case, for example, where the court was very critical about the police investigation. The Zondo Commission had said that the National Prosecuting Authority must be strengthened. And in responding to the Commission's recommendations at point 5.2.18, the President, when he presented the report, the response in October last year, said that to further strengthen the current anti-corruption capabilities, the Investigating Directorate will be established as a permanent entity within the NPA, and ID investigators will be provided with the requisite criminal investigatory powers as contemplated in the Criminal Procedure Act number 51 of 1997. And I think as far as, what is basically what was there with the ID, or is there with the ID currently, is the prosecution-led investigation model, which is a very effective way to prosecute crimes like corruption, as demonstrated by international best practices. And the bill will allow the NPA to apply the experiences gained from South Africa's efforts to tackle high-level corruption. So in a nutshell, this is what the bill is about. And the officials will, in their presentation, go through the clauses of the bill. But before they do that, I just want to touch on one area that complaints have been made that strengthening of the ID is not needed by some people. What is needed is an anti-corruption commission provided for in an amendment to the Constitution. And Chair, these complaints are misplaced because the two are not mutually exclusive. The President established an anti-corruption advisory council in August last year to advise the President on matters relating to fighting corruption in line with government's anti-corruption strategy of 2020 to 2030. They are not just looking at the narrow focus on how retrospective investigations into cases of corruption will be created, but also issues of policy, prevention of corruption, as well as systemic proactive investigations. And that is a longer term approach, which, because of a variety of complexities regarding the matters, is not something that can be rushed or achieved in a short space of time. The President had also in his report to Parliament in October said, and that's at paragraph 5.2.6, that the National Anti-Corruption Advisory Council will, in the course of its work to advise on strengthening the country's anti-corruption institutional arrangements, consider the detailed recommendations of the Commission on the establishment of an anti-state capture and corruption commission and a public procurement anti-corruption agency. Speaking to the chair of the Commission, I understand they're hoping to produce a report by next year, but the issue is these are not issues that can be decided overnight. We do have already some agencies that have been quite effective in the fight against corruption, such as the Special Investigation Unit, the SIU. How are they going to fit in those kinds of issues? But one of the key questions or issues is that it's not just looking at the investigation of corruption, but also of issues of prevention, the powers, the types of structures, how they would fit into the existing architecture of law enforcement, as well as the Constitution, what resources they should be provided with. So, Chair, that's the longer term approach. The bill is something, this National Prosecuting Authority Amendment Bill, is something that's urgently needed now. We want it passed as soon as possible so that the NPA is better equipped to fight corruption cases. In the meantime, the Anti-Corruption Advisory Council will continue with their work and with their report, and when there's final agreement on what is needed, further legislative changes will be made. This bill before you could be an interim measure, depending on the outcomes of the work being done by the Council and government's response thereto. However, the NPA needs to be better capacitated to deal with corruption now. Thank you, Chair. I'll hand over then to DDG Pillay to lead the officials on the presentation on the detail in the bill. Thank you.
Thank you, Chair. DDG Pillay.
Thank you, Chair. Chair, with regard to the background which the DM has given, I will move to the slide which talks to the establishment of facilitating the establishment of a permanent entity within the office of the NDPP. The provisions seek to establish the Investigating Directorate Against Corruption. It provides for the appointment of investigators, the remuneration, conditions of service and powers, and the amendments support the independence of the Investigating Directorate Against Corruption. As indicated, the ID in its current form is not a permanent entity or unit within the NPA. At present, the independence of the ID can be compromised since government departments or institutions can and have in fact threatened to recall or the reassigned employees from the ID. The NPA Act ought to be amended to make provision for the permanent appointment of investigators and the required additional skills in the ID. The discussion of the bill, Clause 1, extends the preamble to provide for the prosecuting authority to fulfill its constitutional mandate in terms of the Constitution and to provide, without limiting the investigative powers of the South African Police Service or the Directorate of Priority Crime Investigations, for the establishment of the Investigating Directorate Against Corruption with investigative capacity, to prioritize and to investigate matters in respect of its specific mandate, which is outlined further in this presentation. Clause 2 is a technical amendment which deals with the index to the NPA Act regarding certain definitions. And Clause 3 amends certain definitions. Clause 4 amends Section 5 of the Act to include investigators as part of the Office of the NDPP. Clause 5 amends Section 7 of the NPA Act by establishing an investigating directorate to be known as the Investigating Directorate Against Corruption, with the aim to investigate and to carry out functions incidental to investigations, and where appropriate, institute criminal proceedings and carry out any necessary function incidental to instituting criminal proceedings relating to offenses or any criminal or unlawful activities committed in serious, high-profile or complex corruption or commercial or financial crime cases arising from the recommendations of commissions of inquiry. Matters reported to the investigating director in terms of Section 27 of the Act. Matters referred to the National Director by the National Director to the investigating director in terms of Section 28(1)(b). There's an error in the presentation. I apologize, Chairperson. Include the existing offences or categories of offences listed in the Proclamation number 20 of 2019. This is a proclamation that established the current ID with a list of offences that it may investigate, and those will be included within the mandate of the new Investigating Directorate Against Corruption. Clause 5 amends Section 7 of the Act by inserting a new subsection to empower the President to establish by proclamation one or more additional investigating directorates to investigate matters that exclude those contemplated in subsection 1, namely the mandate of the Investigating Directorate Against Corruption. Any proclamation issued may be amended or rescinded by the President on the recommendation of the Minister and the Cabinet member responsible for police and the NDPP. Clause 6 effects a consequential amendment to Section 13 by making reference to Section 7.1 or 7.1 capital A and small a. Clause 7 inserts Chapter 3B and provides for the appointment, remuneration, and conditions of service of investigators. Clause 7 also provides for the vetting of investigators and the condition for appointment being in possession of a clearance certificate. The vetting investigation must be conducted in terms of Section 2A of the National Strategic Intelligence Act, 1994, as amended by the General Intelligence Laws Amendment Act. Remuneration, allowances, and other service benefits of investigators are determined by the Minister in consultation with the National Director, the Cabinet member responsible for public service and administration, and the Cabinet member responsible for finance. The remuneration must be on par with or not less favorable than those under the South African Police Service Act. Clause 8 amends Section 22 to make provision for the training of investigators. Clause 9 inserts a new Section 22A for a complaints mechanism for the appointment of a retired judge for a non-renewable period of 5 years to exercise oversight over the investigators. These clauses mirror the provisions relating to the judge appointed for the DPCI. The functions of the retired judge does not derogate from the powers of the South African Police Service or the Directorate of Priority Crimes Investigation to investigate any criminal conduct in respect of investigators. The retired judge shall not investigate complaints about intelligence matters falling under the jurisdiction of the Inspector General of Intelligence. The retired judge may receive complaints in the prescribed form from any person who may provide evidence of a serious and unlawful infringement of his or her rights caused by the conduct of investigators. Any investigator who may provide evidence of any improper influence or interference, hindrance, or obstruction, whether of a political or any other nature, exerted upon him or her in the exercise of carrying out or performance of his or her powers, duties, and functions. The retired judge shall report to the Minister the outcome of any investigation undertaken by him or her, or any referral in terms of subsection 5. The retired judge may obtain information and documents under the control of the prosecuting authority, may enter any building or premises under the control of the prosecuting authority in order to obtain such information and documents, shall be entitled to all reasonable assistance by any investigator as referred to in section 7(4)(a) or any member of the prosecuting authority. Clause 10 inserts section 29(a) in the Act to provide for the powers and functions of investigators. An investigator has the same powers as are bestowed upon a peace officer or police official in terms of the Criminal Procedure Act. These powers relate inter alia to the investigation of offences, entry and search of a premises, the seizure and disposal of articles, arrest and execution of warrants. It provides further that the minister may, by notice in consultation with the cabinet member responsible for police, bestow any power which relates to the prevention, investigation, or combating of any offence or other criminal or unlawful activity upon investigators. Clause 11 deals with transitional arrangements and provides that the current ID shall cease to exist as a separate investigating directorate and shall become part of the Investigating Directorate Against Corruption. It also provides that the investigating director and staff of the ID shall remain in office and continue the functions in the Investigating Directorate Against Corruption. Clause 12 amends the definition of directorate to make provision for its inclusion in the RICA Act, and this is a consequential amendment. Clause 13 provides for the index. Clause 14 provides for the short title and date of commencement. And the schedule amends the RICA Act to cater for the definition of directorate as indicated above. That's the end of the presentation, Chairperson. Thank you very much.
Thank you very much. Members, any questions or comment?
Chair, my
Honorable-
apology. Yes, I can't raise my hands. I'm driving. There's a program that I'm attending with the PCO. Chair, if I can, let me just welcome, Chair, the presentation of this amendment bill, and also thanking the Deputy Minister for bringing it to us, especially after he has mentioned that it is a very important bill and it's going to address some of the issues or the blockage that we have been having in terms of the breakthrough in responding to most of the cases that the department was supposed to be attending to. And also noting, Chair, the Deputy Minister emphasized this issue to a point that I realized that I needed to comment on this one, Chair, especially taking from the comments on the first presentation, that what is it that is going to assist, because the reasons that PLA alluded was the issue of capacity, the shortage of manpower. This bill is important in it must be concluded. And considering that it still has to go to the NCOP and all that, what is it that the department is going to do in speed up in this bill to address the concerns that was mentioned earlier? That is the first question, Chair. The second one, Chair, is this amendment, according to the content, going to address one, the issues of advocate apology. There was a consent earlier, Chair, that the NPA is not an investigating
does not have investigating powers. Now we are coming up with this amendment. I just want to know, is this going to lay or close that gap according to address those concerns that they have been raising even before, when we were raising issues of concerns in terms of the complaints that we were having on the issues of the investigation. And then lastly, Chair, is this bill going to cover also those crimes, the money laundering crimes and those international crimes that we were crying about earlier, that they seems as if there is a lack of attention when it comes to dealing with those big crimes, Chair? I think I will stop there, Chair. Thank you very much. Apology for some traffic.
Thank you very much, Honorable Jalo. Honorable Breitenbach.
Thank you, Honorable Chair, and yes, acknowledge the presentation. It's our view, Chair, that this bill is ill-conceived. This piece of legislation does not do what the Minister tells us it is going to do. The fight against corruption, for a start, will not be won or lost by passing what in my view is slapdash legislation. The National Prosecuting Authority is perennially under-resourced, as is the police. And until they are properly resourced, both financially and otherwise, you can pass as many pieces of legislation as you like. It will make absolutely no difference. Skills cannot be purchased with no money, and people work for a salary. And so you will not attract anybody to the ID unless you can pay them. And you will not attract the kind of skills that you need, the forensic skills that you need, unless you can pay for them. And no legislation in the world is going to change that. So that's for starters. Secondly, this isn't even putting a sticking plaster on a wound. The DSO was effective. It was an effective corruption busting unit, and it did great work. And as soon as it went after politicians, it was disbanded and voted out of existence by a simple majority with great fanfare from the governing party, because they didn't like being the subject matter of the investigations. And so telling us that this is now going to strengthen the National Prosecuting Authority and the ability to investigate and strengthen the fight against corruption isn't true, simply because as soon as the ID housed within the NPA goes after people who don't like it, it will be dissolved again. It means nothing. It is completely meaningless. The fatal flaw of the DSO was that it was housed within the National Prosecuting Authority. We need an institution that is housed outside of the National Prosecuting Authority, that is independent, that meets the constitutional requirements set out by the Constitutional Court, and that has security of tenure. And the making of the ID a permanent fixture, and it's not a permanent fixture, but it's being called that, being made a longer term fixture in the National Prosecuting Authority is not going to solve that problem. And South Africans are being misled, and deliberately misled, by pretending that we're setting up this wonderful institution that's going to replace the Scorpions 201. It is not. It is nonsense. And all of the mistakes that were made with the Scorpions are being made again now. It's as if we've learned nothing. So we will not be supporting this piece of legislation in its current form. The Anti-Corruption Commission, however, offers a solution to the problem. It needs to be panel beaten. It can do with a lot of suggestions, and it is workable. And if it has support, then it can be done within a short space of time. But it will be housed outside of the National Prosecuting Authority, and it will deal with high-level corruption and high-level organized crime. The ID has not done wonderful work in the last 4 years. They may have made some arrests, They may have gotten back 2.5 billion rand. In the bigger scheme of things, that's absolutely nothing. Nothing. It's not even a drop in the bucket. If you compare it to the amount of money that's been stolen from this country, that is nothing. And we have yet to see one conviction, one person going to jail. The only matter that came before court was an unmitigated disaster. So making that permanent is not going to solve any problems. And it's really less than honest to suggest that it will. So this bill has lots and lots of problems, and it's going to take a long time and a lot of argument and a lot of toing and froing and a huge amount of public participation before this goes anywhere at all. Thank you.
Thank you, Honorable Breitenbach. Honorable Swart.
No, thank you, Chair. And from our side, I must say I share Honorable Breitenbach's concerns. As you know, Chair, we were part of the setting up of the DSO, the Scorpions. And whilst the DM does say that the Anti-Corruption Commission is a separate issue that is being looked at, and these are two not mutually exclusive processes, of course, whilst the ID in its present form can be removed by proclamation, as we saw with the DSO, legislation can be changed. And I saw that with my own eyes, how the Scorpions was closed down, not because they were ineffective, but because they were so effective in pursuing highly connected political people. So, Chair, I have concerns about this bill. I do, however, appreciate that it's an attempt to look at seconded investigators and strengthening. But at the end of the day, I think we should rather have spent far more time on the Anti-Corruption Commission, which would situate this body outside of the NPA. And that would satisfy the requirements of the Glenister judgment and what was pointed out in the Zondo Commission. So, Chair, I am deeply concerned about this bill, but we will obviously be engaging now in a process of public hearings, and then we will hear further how we can take this process forward. Thank you, Chair.
Thank you very much, Honorable Swart. Over to you, Deputy Minister, to your team.
Thanks, Chair. If I can just start. I must say I'm disappointed by Honorable Breitenbach's input. Because the issue is we're not setting up a wonderful new institution. We're beefing up what is already there with the investigating directorate, precisely to address some of the problems that she had raised. And this is a stopgap measure. So I would hope that members would, for the good of the country, agree with this amendment bill whilst the Anti-Corruption Council do their work. Honorable Smart says that we should be working on that work, but they've got to do their work first. Honorable Breitenbach knows how long things take. The DA had a press conference in July 2021, so 2 years ago over, to announce the introduction of new legislation which will create a new independent Chapter 9 institution called the Anti-Corruption Commission. And she spoke about the DA introducing 2 private members' bills. That was in July 2021. Again, then in March last year, so over a year ago, the DA again spoke and said, Honorable Breitenbach, the DA will be accelerating the introduction of our comprehensive Anti-Corruption Commission private members bill. I assume, and we have no bill, there's been no Anti-Corruption Commission bill tabled. I assume, Honorable Breitenbach, that's because the issues are complicated as to how you can't rush into something. What this bill is doing, and it's not, as you described it, slapdash, it is basically beefing up the capacity of what is already there, the investigating directorate. It will give it greater investigating capacity. It does have some, but the problem was that they had to rely on officials to be seconded. So I agree, we need to have longer discussions, but right now we need this bill. And having this bill is not going to stop those longer term discussions once the council has reported. Just maybe some issues, the issues been raised, I think, by Honorable Breitenbach, that, okay, this can be disestablished as the Scorpions legislation was repealed. And she says it was because ANC politicians were being investigated. That was not accepted by the Constitutional Court. And in fact, it was the minority judgment that by one of the then Chief Justice had specifically said, no, that wasn't, there wasn't evidence that was the case. They want something in the Constitution, which then obviously requires a 2/3 majority to change it. But that can still be changed with a 2/3 majority. And then also a Chapter 9 commission is not the panacea that some people make it out to be, as evidenced by what has come out in the report that we will be voting on Monday on the public protector. The other issue is references, and I think Advocate Hoffman, as the DA's ally, and had spoken about the requirements of the Constitutional Court in the Glenister case. Well, those were met by the amendments to the Police Act. I mean, it required having to be looked at by the court on more than one occasion, but that complied with it. And I'd be interested to see where this provision that this must be outside of the National Prosecuting Authority, who have the constitutional powers to prosecute. But the issue, though, is not whether it should be inside or outside. Those are issues that we can address later, because it will take longer to find a solution or to come up with the correct architecture. So I just wanted to give that by way of background. I know we're going to elections next year, but I hope that this will not be unduly politicized. This is not a complicated issue. It is giving the investigating directorate the power to appoint its own investigators, and then a complaints mechanism was seen to be important. That is largely all it is doing. And we do feel that in the interim, once the bill is passed, then that can be done, and we can have a more effective investigating directorate in the fight against corruption. The issues that Honorable Jele raised, I think, I mean, the mandate is, this is a investigating directorate against corruption, to investigate particularly serious criminal or unlawful conduct committed in serious, high-profile or complex corruption, commercial or financial crime. But I would hope, Chair, that this is, as I said, this is a stopgap measure. The issues that both Honourable Breitenbach and Honourable Swart have raised are issues that do need to be debated, but we need to let the Anti-Corruption Council complete its work and to produce a report which then can be examined. Chair, I'll then hand over to DDG Pillay.
Thank you very much. Honorable Breitenbach, your hand was up. Was it a point of order or what?
No, thank you very much, Chair. I was going to reply to the Deputy Minister, but let's not make this a debate. We'll deal with it as we deal with the legislation.
Okay, that's good. Thank you very much. DDG Pillay.
Thank you, Chairperson. I would just like to respond to the question from Honourable Member Maseko Jele regarding the mandate on money laundering cases. It is specifically included through the inclusion of the offences that were listed in Proclamation 20, which deals with the inclusion of offences under poker. And that's the one way it's included, but also any offences arising out of a commission of inquiry, which includes the State Capture Commission. So those offences will be included within the mandate of the new ID. Thank you, Chairperson.
Thank you very much. I see there are no further questions or comments. Members, we will take the two bills. Honorable Deputy Minister.
Chair, sorry, I just wanted to come after you've spoken on the process, but please, I thought I might need to ask something. I was putting my hand up preemptively. I'll lower it and then I might raise it after you've spoken.
Thank you very much. The two bills, the recap bill and this bill, we will now take them for public comments. Then thereafter we will proceed with the normal processes of dealing with bills. We will ask the parliamentary the parliamentary processes to be much faster, especially the procurement, because at some point it's one process that delays us. That as soon as we conclude with our meeting today, the processes of ensuring that these bills are advertised urgently is embarked upon. Thank you very much, members. Deputy Minister.
Chair, you've largely covered me. I mean, the divorce amendment bill took, I think, about 3 weeks after introduction into Parliament to be published for comment. So it would be appreciated if those procurement issues, those administrative bureaucratic issues within Parliament can be addressed. The RICA bill was tabled last week. The NPA amendment bill was tabled on Tuesday, or was introduced on Tuesday rather. Thanks, Chair.
Thank you very much. Members, that brings us to the end of our meeting.
Chair, sorry, just the issue of you didn't adopt the report on the Judicial Matters Amendment Bill. I think it was because of an absence of members. I don't know if you're going to hold it over to another meeting, but it would obviously be useful to have that bill and report sent to the House so it can go to the NCOP.
Thank you very much, members. I think let's try and do it now. We have agreed with the bill. Now we need to pass the report. We have gone through the report. Is there anyone who moves for the adoption of the report on Judicial Matters Amendment Bill?
Chair.
Honorable Chair.
I move for the adoption of the report.
Honorable Chair moves for the adoption of the report. Any seconder?
Honorable Neo Druchen seconds.
Honorable Neo Druchen seconds. Any objections? Honorable Breitenbach.
Thanks, Chair. We reserve our position and we note the co-chair, the Deputy Minister. It's the second time this week he's tried to co-chair the meeting.
The Democratic Alliance reserves its position. The report is agreed to. Thank you very much, members. The meeting is adjourned.
Thank you, Chair.
Thank you very
Thank
much.
you, Chair.
Thank you, Chair.
Thank you. Committee Secretary, is here?
Yes, Chair.
The link for the other meeting is the same link, or there is going to be another link?
No, it's the same link, Chair. We will just remove. We urge everyone to exit, and those who stay will remove them, Chair, and we'll tell you when the room is clear. Just now. Maybe we can take 5.
Recording stopped.
Can we take 20 minutes?
Okay, Chair. Just okay. So it's 11 now, so we can start at 20 past.
Okay, sure.
Okay, Chair. Thank you.
We are exiting, Sia. You don't have to remove us.
Okay, Honorable Ramlubeng, thank you for exiting. Otherwise, we'll deal with you. Dr. Lutz.
Hi, Sia. I'm here. I'm just alerting Shamaine and Lonwabo
Yeah,
to the time.
yeah, I think that 20 minutes is
Yeah.
giving us that leeway.
Yeah, I'm because I know Shamaine was busy dealing with something just for the NI secretary. So I said I'll alert her when the manca starts. I'm just giving them that heads up.
Yeah, you can also grab a coffee.
Load shedding. So cold coffee.
But I think we must buy flasks, comrades. Like, must have flasks. Must go back to the times where electricity was not there now.
I don't have time to shop, Sia. You guys are keeping me too busy. I don't have time to shop for a flask.
Telling you, it's about, in a day, it's about 10 hours where you don't have electricity. It's out of 24. To 10 hours, you don't have electricity. And
Yeah,
then you have to sleep for 8. So it's 18 hours where you're not using. Yeah, it's a mess.
I'm not even sleeping for 8. I'm getting up halfway through the night to make sure my alarm doesn't go off when the power goes back on. The neighbors don't like it.
Yeah.
Leadership.
By the way, I think the streaming thing is still on.
The streaming.
Yeah.
Yeah, I see them there.
No,